Welcome to Tax Sale Insiders, the latest from Tax Sale Resources, bringing you information about tax sales from experts in the industry. We interviewed Bob Kaiser, partner at Taylor & Kaiser based in New Jersey. Bob was president of the National Tax Lien Association with his tenure ending in 2020. He has been practicing in the real estate capacity for over 38 years and specializing in tax liens for over 25. He now practices in New Jersey and Pennsylvania, and in this episode, Bob deep dives into the bankruptcy law and how bankruptcies affect investing in tax liens in New Jersey. This is Bankruptcy Law 101, so sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
Welcome everybody to this episode of Tax Insiders. We're lucky enough today to snag some time from Bob Kaiser, and Bob's an attorney with Taylor & Kaiser in New Jersey, also a previous president of the National Tax Lien Association with a great tenure a couple of years ago. I've been a member and known Bob for several years now. Anyway, welcome, Bob.
Well, it's nice to be with you. By the way, I've been at the NTLA since the very first day, so.
You were an original member. When did NTLA get started?
1997, I believe, was the first meeting.
Yeah, a little longer than I would remember that. I think I was still in high school at the time, quite honestly. Well, Bob, I guess, I know quite a bit about your background, but everyone else listening doesn't. So I guess tell us a little bit about your background. How'd you get into the industry? It's always a fun story, kind of hearing that stuff.
Well, I've been practicing law for 38 years, and I started life primarily as a bankruptcy attorney, a trustee's attorney, and then later a bank attorney representing lenders in workouts and in their loans. I had a national lending client, and one of the times I was with a large firm that was based in Florida, and one day in 1996, they fired their whole lending department. And a bunch of them got hired by a company who old timers will know, but others won't, Capital Asset Research Corporation, who was not far from where their corporate headquarters were, the bank they left. And they called me in 96 and said, "We think you can do this. And, we have a lot of tax lien work. We're using attorneys, but let's see what you can do." In the beginning, in 96, 97, I was only doing their bankruptcy work, the cases that had gone into bankruptcy. And then later they started using me for their tax foreclosure work. So it went from something that I knew nothing about to completely taking over my life. So they had so much work to do and had so many liens that, let's just say, when they were already in liquidation mode when I was representing them, and it took probably 7 years to liquidate their liens. They had 20,000 liens in New Jersey, and they were in 20 states. So they kept me busy for a while.
Got it. Yeah, that'd keep many attorneys are busy for a long time, right?
Yep. And so I've been doing that. Like I said, I had my first cases in 96. So it's coming up on 25 years that I've been doing it.
Gotcha. Well, so you had a little more, I'd say, a more normal introduction in the tax lien space than many. At least it was a job offer as opposed to, I guess I hear a lot of it kind of fell into it, or it was where the work was, sort of a thing. So I guess.
Well, that's what you have to do. I have to tell you though that I gave my first seminar on tax lien foreclosure practice before I had seen my first final judgment. Which is I thought was a little premature, but people.
Hey, if you know what you're doing,
that's right.
All that matters.
It was different then, though. It was different. Electronics have sped it up. There are cases I'd still be working on today from 25 years ago if they hadn't streamlined the practice. It was so slow then. Now, we don't, everything is electronic, so.
At least New Jersey is
Yes.
a little closer to the 21st century. There's still some jurisdictions and states out there that probably operate much like they did in the 1940s and 50s.
And Brian, like I said, I wanted to make sure that I mentioned at the outset, I'm admitted to practice in New Jersey and in Pennsylvania. And even though I'm here to talk to you about the bankruptcy practice, and even though the bankruptcy is federal law applies the state law in determining what your rights are in a bankruptcy. And each state, as you know, because you work in multiple jurisdictions, has a different product, has different rights, and those rights will affect what you do when you find out about a bankruptcy. I can tell you what to do in New Jersey. I can tell you some of what to do in Pennsylvania, although there isn't a lot of tax lien work in Pennsylvania. But how that applies in Georgia, how that applies in Florida, it can be very different. And not only that, but bankruptcy practice is a matter of the local rules. And local rules is a capital L, capital R. That's actually real law that each jurisdiction passes. And you have to know the local rules to know what you have to do in order to protect yourself. Now, some rules are from the bankruptcy rules, such as 70 days to file a proof of claim. That's the same regardless of what your jurisdiction is. But I would only admonish the people who listen to this to know I can give you the general, but to learn the specific, you have to get counsel who understands your state's laws and practices.
And that's, I guess that's the beauty of and the frustration at the same time of tax liens. Every state's different. Counties interpret state statutes differently. Just because you understand how it works in this little area doesn't mean you have a good idea. In some cases, can actually get you in trouble in other areas.
Oh yeah, absolutely.
A good example.
And when I talk in this about the way things are done, I'll be very specific and say, this is the way we have to do it in New Jersey. It's not necessarily the way you have to do it.
Got it. Good. Well, you mentioned exactly what we're going to talk about today. I guess I printed out a copy of the white paper you wrote for us, Bob. And we can talk a little bit about New Jersey in general, but I do want to focus on the bankruptcy process because it is so. It seems to come up in enough to be something you don't just ignore and say, okay, we'll address that when the time comes. But I guess why should tax lien investors be concerned about bankruptcies? Like what percentage of roughly of tax liens in New Jersey end up in this state?
Well, I would be going more on anecdotal. I would say for me, it's probably not more than between 1% and 5%. But I've also heard, again, anecdotally, and I've been reading about this, that the numbers are going to begin to expand, rather unfortunately. So we're just going to have to wait and see. I mean, remember, as I'll talk about later, there are 2 times now in New Jersey when people file. There's while the foreclosure is going on, and then there's after they've lost the property, and that's a whole new ballgame. That's a different situation. We were accustomed to bankruptcy filings to save something that you already had. But now bankruptcies are being used to get back something that you've already lost, and so that's a different situation. But really, why you should be concerned about bankruptcy is because, as we know in this industry, time is money, and bankruptcy slows you down even under the best of circumstances. Even though, at least in New Jersey, and I think in many jurisdictions, you're entitled to whatever your interest would be. So it's not a question of will you lose that interest rate, whatever it is. In New Jersey, it may be 18%. It may have been bid down. You will, in a successful bankruptcy, and that successful is an exception, I would say, not the rule. In a successful bankruptcy, you will get your full interest. But most of my clients are not interested in waiting 3 or 4 or 5 years to get paid. That's not an effective use of their money. So that's why you need to be concerned. You also need to be concerned because bankruptcy imposes a new set of rules on you and new restrictions. And if you're not aware of them, you can run afoul of them. You can even imperil your investment. So the most important thing about dealing with bankruptcy is be diligent. It's not that difficult to be diligent, but don't ignore it. And I think the overarching thing to know about that is anything that you do in a bankruptcy that you do while you're ignoring it is void. It's as if it didn't happen. So for example, if you're paying me to foreclose on a property and the owner is in bankruptcy, nothing that I do will have any impact. Even though I can file pleadings, even if they don't tell you, the debtor doesn't tell you that they filed, even if the debtor's attorney doesn't tell me, nothing that I do is valid. So it's a complete waste of your time and my time and your money. So it's always best to be diligent, to pay attention.
Got it. And you'd hinted at it, not believe it or not, I did do my homework today, Bob. I did read your white paper, learned an immense amount. And that's one thing. They say the beauty of the taxing industry. I come from the aerospace industry, launching rockets, and it sounds all glorious, but I learn more on a daily basis within this industry than I did in my previous life. So anyway, I learned an immense amount reading through your paper, but I'm certainly not an expert by any means, but I'll try to ask a couple questions that really stuck out to me. And one of the things you already mentioned is that what you do in a bankruptcy really depends on when that bankruptcy is filed, whether it's before or after that sale or final judgment. So maybe we kind of step through this at each of those potential filing points. And let's start with before that sale, the tax lien sale ever takes place. If a bankruptcy is filed before the tax lien sale, what does that situation look like?
Well, first of all, we're presuming, as we must, that either the selling authority, which in New Jersey would be a municipality and not a county, either didn't know or chose to ignore it. Both occur, by the way. And as I just said, actions taken in violation of the automatic stay, and we'll talk about that, what the automatic stay is later, are void. So therefore, in truth, what you have purchased is nothing, even though you do think you have something. And by the way, in New Jersey, you may be paying subsequent taxes on it after you purchased it, but the sale itself is invalid. Now, I know from being involved in the national organization, more than New Jersey, other states have sale and error procedures. New Jersey really doesn't have that. It's very much the exception than the rule. Mm-hmm. But in effect, a sale in violation of the automatic stay is a sale and error because they couldn't do it. The towns, and there are 567 tax districts in New Jersey, who have reasonably good counsel, are told, if you want to sell a tax lien at this point, get stay relief so that whoever buys it from you has purchased something that's valid. But many of them don't, and you don't find out sometimes until you send it to your attorney 2 years later at the end of the redemption period, and you get a title search and you say, when they did that tax sale, there was already a bankruptcy going on. Now, understand, I have also, and I want to back away from New Jersey for a second. I do understand that there are some jurisdictions in this country that take the position that the sale of a tax lien is nothing more than the assignment of a lien that already exists. It's not creating something new, and it's not trying to enforce rights against the debtor. If I have a lien now and it's valid, I could assign it to you during the bankruptcy. The assignment of the lien is not considered a violation of the automatic stay. It just means somebody else owns it. And there are some jurisdictions, I understand, that take the position that that isn't a stay violation because the municipality or the county already had a lien and all it did was convey it to you. That's not the law as I know it here in New Jersey, and I would never take that chance. For me, now, what do you do when that happens? You have two choices. One, as I said, is you go back to the town as soon as you find out and you say, this was a violation of the automatic stay. See, here's the bankruptcy filing. Here's when you did your sale. You can see the guy was already in bankruptcy. And the municipality, generally speaking, will say, yeah, you're right, let me pay you back. Now, the issue there becomes, what's the interest rate that you're going to get? It may be significantly less than the rate that you're supposed to get by state law, because in invalid tax liens in New Jersey, you get the judgment rate generally, which if you've ever looked at the judgment rate in any states, it's very low, in the 1% and 2% range. Now, so the shorter the time you own that lien while it's invalid, the less money you're going to lose on the interest. The other alternative, and this is a real alternative, is you go to the debtor's attorney and you say, hey, I bought this lien. Looks to me like it was a sale that was invalid because your guy was already in bankruptcy. But you do know, debtor's attorney, you've got to deal with this, right? You do know it's not going to go away just because it was an invalid lien. Your guy does owe the taxes. He owes it to the municipality and not to me, or not to my client. And he owes the municipality 18%, whereas my client bid it down. You might be better served, debtor's attorney, if you agree with me that my client holds this tax lien, and then we can get an order from a court that says that sale that took place months or maybe years ago was valid. You essentially validate the sale that already took place. And you do that because, first of all, your client bought the lien and wants to get the benefit of it. And second of all, the debtor's attorney does better for his client by having you as the lien holder than he would if it went back to the municipality. So it's really just figuring out what works for both sides. But it's not generally that contentious a situation. But the last thing you want to do is pretend it didn't happen. Like I said, in all bankruptcies, don't ignore it, because nothing that you do will work for you if you ignore it.
You mentioned a couple things there. So the fact that almost all decent liens, especially in today's market, are being bid down to really a 0%.
Right.
And actually there's premium bid above it. How often does the bankruptcy representative, their attorney, would they agree to something, to a structure like you mentioned, where it's, hey, you either pay the municipality 18% or you can validate my sale? Is that a pretty common?
It's not that common that they do it, but I've seen it from time to time. And as often as not, I get the debtor's attorney to agree to it. Now, understand the premium has nothing to do with this, because the premium is never owed by the debtor. Right. The premium is always held by the municipality. And later on, I would tell you that the last thing you do is put a premium in a proof of claim. That's poison. And there's case law that says it's poison. So since everyone knows the debtor doesn't owe the premium should never appear anywhere in your proof of claim. It can be a problem sometimes because, I'll ask for a redemption statement from either my client or from the municipality in order to attach it to my proof of claim, and it'll have the premium on there. I gotta wipe that baby out. I said, no, we're not trying to get that.
Got it. So you mentioned the premium, though, not on the case, but in the event that you find out that the bankruptcy was filed before you bought the lien, you go back in a circumstance and ask for the principal back from the county or from the municipality, I guess, in New Jersey. Sorry. Does the premium get returned, or is that a whole separate? Oh, no.
The premium must be returned. Okay. Yeah, everything that you paid. The only issue will be what interest rate they'll give you, not will they give you back everything you paid them. I mean, because in order for them to agree to that, clearly the town has been convinced by you, and it's not hard to convince them that what they did was wrong. And most of the time, it's because they didn't know themselves. It wasn't that they're just ignoring it. I mean, we all rely upon the debtor and debtor's counsel to put together a list of everybody that's owed money. The debtor's counsel, and I haven't been a debtor's counsel since 2000, back when I used to do some debtor's work, rarely would order a title search. If you ordered a title search on every one of your clients, they don't have money, so they don't really want to pay for that. You would see whenever there was a tax lien sale, there would be no question. But other than that, the debtor's counsel is just relying upon what her client is telling her. And if the client doesn't say, I stopped paying my real estate taxes years ago, then they might not list either the town and certainly not you, the private lien holder. So it's almost always, it's rarely someone who just says, the town that just says, you know what, we want to ignore this. No, they just don't know.
Yeah.
It's best for me, when I find out about a bankruptcy, sometimes I'm the one who tells the municipality and say, by the way, that property owner of yours that's not paying, they're in a bankruptcy now. You ought to think yourself, municipality, about filing a proof of claim for your taxes for the part that you didn't sell.
Gotcha.
Good to get along with your local tax collector,
Yeah, that's always key, right?
That's right.
The other thing that you'd mentioned, for anybody that buys liens on the secondary market, from investor to investor, if a lien is in a bankruptcy, the ability to sell that lien to a third party isn't violating anything or doesn't invalidate the lien. You
Absolutely not. And it's, as a matter of fact, there's a specific procedure in the bankruptcy court and on the docket for showing that an assignment has taken place. It's some very simple pleadings that you file that say, here's the new holder. You make sure if it's for example, if it's a Chapter 13 and it's in plan, that makes sure that the Chapter 13 trustee also knows, so the payments start getting redirected to the new holder of the lien as opposed to the old holder. Yeah, it's as you probably know, there's a fairly active trade in debt in the bankruptcy court, and that's no different in tax liens. I mean, what you do want to make sure, though, if you're the one who's taking it by assignment, is that the proof of claim was filed correctly in the first place. Because if the lien holder blew the deadline or didn't properly file the claim, you, the assignee, are going to get stuck with that. The fact that you're a new holder doesn't give you the right to fix what was done before. So your due diligence has to include seeing what the bankruptcy docket and what the claims register says about that particular claim. But no, I've done it many, many times. I have many clients who assign liens or take assignment of liens in bankruptcy. I think the ones who take the assignment are counting on the bankruptcy to fail. They're not looking for the stream of payments.
Right.
That's not a bad bet.
Okay. But there's, like you said, definitely additional due diligence must be done on anything that includes bankruptcy.
Not hard though, because remember, everything is available. You can see anything. You can log onto the bankruptcy court system, and you can see exactly what's going on in the case. You can see exactly what the proof of claim is. You can open the proof of claim, see all the exhibits, see that they did it right. It's easy due diligence now, but
hasn't always been that way, right?
No, absolutely not.
Okay.
No.
Anything else on the pre-sale you want to touch on before we kind of go into the next phase of being?
Not so much. That's actually more, like I said, more the exception than the rule. It's just like I said, it's just falls into the general category of you must be diligent when you're a tax lien investor. But you already knew that.
Got it. Well, yeah, and we try to relay that to everyone else in the audience as well. Due diligence.
Yep.
Due diligence. All right, so we've covered, I think there's three points in time that we kind of put or different buckets that we put these in depending on when that bankruptcy was filed. And we talked about before the tax sale ever takes place, right? So now let's move on to the time period between the tax sale and a final judgment. Right. So anytime during that redemption period, what's different? Here's
the thing. And this is pretty much the same for either, meaning whether I started the foreclosure or not, but I tend to see them more when I've started the foreclosure, obviously, because first of all, I've got the lien then, and the client doesn't assign it to me until then. And second of all, it may be my foreclosure that prompts the bankruptcy filing. So therefore, depending upon the type of bankruptcy that's filed, that will determine the next step you take. Now, invariably, I say invariably, but there's one variation. Invariably, the first thing you're going to do is file a proof of claim. In New Jersey and also in other jurisdictions, your attorney, assuming that you've retained one, will also file what's called an entry of appearance. That's just a document that goes on the docket that means anything that happens in that case, you get served with. So that way, in order for me to keep track of what's happening in a bankruptcy, I don't have to keep going on the docket. Anytime anyone files anything, anytime a plan is filed or amended, anytime an objection is filed, I get copied on it electronically. But so the thing you do first is you file your proof of claim and your attorney files an entry of appearance. The type of proof of claim will be determined by the type of bankruptcy that's filed. And there are basically 3 types of bankruptcies. There's more than that, but I'm not going to mess with Chapter 12 because I frankly don't deal with many family farmer filings. But I know it's, in some jurisdictions, I'm sure it's a bigger deal. Here we have essentially the Chapter 7, the Chapter 11, and the Chapter 13. The Chapter 7, which is the liquidation, can be broken down into 2 basic types. One is the no asset case, and the other is the asset case. The vast majority of Chapter 7s that you will see are no asset bankruptcy, no asset Chapter 7s. That means that the debtor doesn't own any assets that are above their liabilities plus their exemptions. You're allowed to keep certain amounts of your assets. In New Jersey, we use the federal exemptions, and I don't remember what the number is right now. Like equity in a home, it used to be 15,000 back when I did debtor work. I think it's much higher than that now. It's like maybe 17 or 18,000. And if there are 2 owners, it's double that. But if the debtor doesn't own anything, any assets above, it's his or her exemptions, that's a no asset case. You will get notice of that, and it will say in big print, do not file a proof of claim. There will be no distribution here. And you are stayed by the automatic stay, which I'll talk about again in a number of contexts. And you can either move for stay relief, or you can wait the approximately 3 to 4 months for a no asset case to run its course. And as soon as it's finished, the automatic stay is gone, and you can either resume or start whatever your foreclosure action is. Chapter 7s used to be more prevalent than they are now, because now there's what's called a means test, meaning you have to really show that you can't afford to pay any of your creditors before you're allowed to be in a Chapter 7. Because I haven't done any debtor work since the means test started, I haven't had to do the calculation, but it's a pretty fancy calculation that says, essentially, if you have any regular income, we're not going to let you be in a Chapter 7. You're going to have to file a Chapter 13. So we don't see it that often. We don't see an asset Chapter 7 that often. However, if you do see an asset Chapter 7, you do file a proof of claim. And in that instance, the proof of claim is how much was I owed on the date of the filing of the bankruptcy. It's an asset Chapter 7 because a Chapter 7 trustee looks at that and says, this real estate will yield something for the creditors, that they have equity in this real estate. The trustee is then obligated to sell it. And when the trustee sells the real estate, you get redeemed at the closing almost always, and with full interest at the closing. So that's the asset Chapter 7. Doesn't happen that often, because if you think about it, if somebody's got equity in a piece of real estate, typically they're not going to want a trustee to sell it. They're going to try to do something with it. They're going to try to preserve it, or they're going to try to sell it themselves. So that's the Chapter 7. The Chapter 13 is the bankruptcy you'll see the most often, and the one we in the tax lien business will see more than almost any other. And that's what's referred to as the wage earner's plan, although it's a little bit of a misnomer, but that's what it's called. And that is a bankruptcy where the debtor generally is, the precipitating event usually is some kind of a foreclosure, but not necessarily. It's trying to preserve equity in an asset. And the debtor does that by proposing a plan to repay creditors. Secured creditors have to be repaid in full. Well, that's a little misleading. A mortgagee, and the mortgage is usually the act that moves someone into a Chapter 13, has to have its arrears, how far behind you fell has to be paid through the plan, and you have to continue to pay your regular monthly mortgage payment. A tax lien investor doesn't have arrears.
Right.
We're owed the full amount. So when we are included in a plan, the tax lien claim is the full amount of the claim with interest over the life of the plan. And the interest rate is whatever the interest rate would be if you weren't in bankruptcy. Meaning if you bid the initial certificate down to zero, that portion of the principal accrues interest at zero. If you paid subsequent taxes and it's above $1,500, and it always is, that's going to earn interest at 18%, unless it's a municipality that did something strange, and there are one or two in this state that have. They have lowered the rates. But basically, you're entitled to whatever your interest return would be if you weren't in bankruptcy. And your proof of claim must reflect that. Meaning, when you get someone to file a claim for you or you file it yourself, you have to calculate what the total amount of your interest would be over the life of a plan. And that has to appear in the proof of claim or you won't get it. That's a bit of a complicated calculation if you think about it. Essentially, what I attach is an amortizing schedule. Generally, it's over 5 years, because that's how long most of the plans are, of the principal portion of my tax lien that is accruing interest, not the initial certificate if it didn't. And if I've got an interest rate on my initial certificate that was bid down to 5% and the rest was 18, then I have to have two amortization schedules. I have to amortize the certificate at 5 and the subs at 18. Then you add whatever your lawful fees and costs are. And if you're in a foreclosure in New Jersey, you're entitled to certain attorney's fees and costs. They don't accrue interest. You add all of the pre-petition interest that accrued before the bankruptcy. Again, that doesn't accrue interest. That's just a line item. The interest accrued. So the only part of your claim that's accruing interest is the part that would be accruing interest in any event. And that all has to be in your proof of claim. And if it isn't there, you aren't going to get it. I say this because I see proofs of claim who are filed either by pro se litigants or even by attorneys who don't know. And they say, well, this is how much was due and owing on the date of the filing, and that's the amount in the proof of claim. And they're not going to get any interest. They're going to get paid over 5 years without interest. And that can be a big loss. I mean, we have a lot of math people in this industry. They could probably tell you faster than I can how much interest they'll lose over that 5 years. So you've got to make sure you get someone who knows what they're doing. And it's a complicated claim. And the other thing I wanted to point out, and I pointed this out before, was, you're on my tape, right? That I'm being taped right now. My wife decided she wanted to be in this.
Back in audience.
Yes. That you do not ever include the premium in that proof of claim, because if you do, there is case law that says your certificate can be invalidated, not by the bankruptcy court, by the state court, because you've tried to collect more than you're entitled to under the state law. So it was a big case. It was a huge premium that was invalidated. I won't mention who it is, but it was a 6-figure premium that was included in the proof of claim and a 7-figure tax lien that was invalidated.
Ooh, rough.
When that happens, it catches everybody's attention.
Yes. And it's really because the premium isn't due from the debtor, it's due back from the municipality.
And one other thing about the premium, they changed the law in New Jersey, I think, I can't remember how many years ago, it wasn't that long ago, that because in New Jersey, to get your premium back, you have to be redeemed inside of 5 years. Mm-hmm. But of course, most bankruptcies go well beyond that, especially if the bankruptcy was filed 4 years after you bought the certificate. So the premium period, the period at which you could get your premium back, is extended by 1 day for every day that the bankruptcy is open. So that way you can still, if my client gets paid in full through a bankruptcy plan that took 5 years, even if it was 7 or 8 years after the certificate was purchased, I can go back to the municipality and say, well, we just got paid in full, we were redeemed, it's time for our premium back.
So I think I'm going to ask the question a little different, but I think you already answered it for me. So you have that premium paid. Typically, you have to file for that within 5 years, right? So if somebody files a bankruptcy 2.5 years in, halfway through, for every day that bankruptcy goes on extends the period you can
Ends the-
claim that, right? So
That's right.
if it goes 5 years from that 2.5, you have 7.5 years to get that premium back.
That's
Now,
right.
the other part of that question is, do you have to wait that 7.5 years, or is there any point during that bankruptcy you can go back to the municipality and request those premiums before that 7.5 years?
The only thing that triggers the refund of the premium is full redemption.
Okay.
And so, because in theory, up until you're fully redeemed, you could still end up with the real estate. And you never get your premium back if you end up with a real estate. I mean,
Got it.
bankruptcy plans, as I said, fail. And sometimes the debtors do lose the real estate. So you're not going to get the premium from the municipality in advance of being fully redeemed. And even then, they can be really tough on making you prove it. I've had to produce the trustee's ledger to the municipality and say, see, there's my proof of claim. See, there's the amount the trustee dispersed to my client. Notice how those two numbers are exactly the same. That means we were paid in full. They want proof that you actually got redeemed in the bankruptcy, because the payments don't go through the tax collector. In New Jersey, all other payments go through the tax collector. Redemption is always through the collector. The exception is bankruptcy payments. So the collector doesn't ever know how much you've received until you show the collector. That can be a bit hairy, especially when there's only partial payment.
Yeah, well, that's what I was curious of. So if you put the wrong amount, like you file your proof of claim incorrectly, right? You forget about all that interest that's due to you. Are you able to ever actually show that you were redeemed in full in that case?
Oh, well, sure, because
Okay.
I mean, yeah, since I don't file incorrect proofs of claim, I don't actually know from my own experience about this, but I assume that if what you filed a claim for is what you got paid, it won't be that hard probably to prove it to the collector, because the collector probably gave you the redemption statement that was due and owing on that day anyway.
Right.
If the collector didn't calculate your interest in the bankruptcy, the collector said, "Oh yeah, you got exactly what I sent you." Yeah, I got it over 5 years, but
Those are a little easier to make numbers match, but
That's right.
Obviously burns the investor in the process. About chapter 13 bankruptcies. So what's different between chapter 11 and chapter 13?
Well, chapter 11s is a more complicated situation. At chapter 11 is often a business, but can be an individual. It generally is filed, first of all, because businesses are not allowed to be in chapter 13. So you can have a small business that's in a chapter 11. You cannot have any size business that's in a chapter 13. And second of all, because there are debt limits in chapter 13s if it's an individual. And the debt limits are not that high. I mean, they're high enough. They encompass a lot of people. But if you're sort of a high roller, a high net worth person, and you get into a bankruptcy situation, the chapter 11 is more likely where you will end up. Now, where I see chapter 11s most often as it relates to the tax lien industry is what's called the single asset case. And that is when an entity, usually an LLC, owns one piece of real estate. And that's called the single asset chapter 11. It's like all chapter 11s in that it requires a plan, that there's not an automatic trustee as there is in a chapter 13, but it's supposed to be faster and simpler. The debtor is supposed to file and this is when the sole source of revenue is from a single piece of real estate. And as you know, I mean, in the real estate world, that's very common, since people set up special purpose entities for single pieces of real estate. Now, a plan has to be filed within 90 days of the filing of the bankruptcy. In a chapter 13, plans are filed immediately. In a chapter 11 that's not a single asset real estate case, it can take 3 months, 6 months to get the plan filed. It's usually the judge who says, "Yo, you got to get this plan filed." But there's no hard and fast deadline. But in a single asset real estate case, there is. And the plan has to be confirmable within a reasonable period of time, whatever that means. But the difference in a chapter 11 in the proof of claim stage is that you don't know the time period over which you're going to be paid. And so therefore, you can't file a proof of claim that includes unaccrued interest. You can't say, okay, this is going to be 5 years. I'm going to put a 5-year amortization schedule in. You file your proof of claim that shows the amount that's due as of the date of the filing. And your claim clearly states interest will continue to accrue until this lien is redeemed. And that's honored. That's the way it will be. So if there's a plan, your claim will have to be recalculated at that time. If there's a sale of the property in the Chapter 11, then you'll be redeemed with the accrued interest as of the date of sale. And by the way, I didn't mention in Chapter 13, and I should have. There are Chapter 13 plans that are called sale plans, and they're really either sale or refinance plans. And in that instance, even though you may have filed a proof of claim that has unaccrued interest in it, you'll get paid to the date of redemption. You won't get paid necessarily the amount of your proof of claim. And in fact, if I know it's going to be a sale plan, I will file it as if it was a Chapter 11, meaning I will say, okay, this is how much is due and owing today, but we all know that in a year, when you say you're going to sell this property, it's going to be different, and that's what you're going to pay me. And those are always respected by the trustees. They have to be.
Okay.
So the Chapter 11 is basically, it's in a way a little bit like a Chapter 7. You file, if you have an asset Chapter 7 or a Chapter 11, you file a proof of claim. And by the way, every proof of claim should have the same thing, which is proof that you own a tax lien. It should have the tax lien as an exhibit. It should show the tax lien was recorded, because you have to have a recorded instrument in order for it to be valid in the bankruptcy, and they always are. So that's the difference with the Chapter 11. Now, there are some new Chapter 11s. I don't want to get into it too much. There's a new version of a Chapter 11, which looks very much like a hybrid between a 13 and an 11, meaning there's the trustee that's appointed in every case. You get a plan that's between 3 and 5 years, but it's a business. It's called the small business. It's essentially the small business Chapter 11 or sub-Chapter 5.
Okay.
And I haven't seen many of them. I'm told that the pandemic is going to cause a lot of these to be filed, and so I'm going to learn a lot about it. But, because it's set up for small businesses. It has a $7 million debt limit, that 7.25 actually. And that debt limit was increased in the CARES Act, or whatever that act was that they passed in the to allow more businesses to file it. We'll see what happens with that, but it's going to be more like a Chapter 13, I think, in terms of the practice for creditors, because I think we're going to end up filing proofs of claim that have interest over 5 years in them, even though it's a Chapter 11, and the Chapter 11. These new plans are going to be on a form that's produced by the bankruptcy court. It's not going to be like a Chapter 11 plan, which could be 25 or 50 pages. This is going to be a form plan. So it should be simpler. It's supposed to be cheaper. That's the whole point. Chapter 11s can be very expensive for the debtors. And in order to make it more accessible to small businesses, they've come up with this new type of Chapter 11. So that's enough on the different types of bankruptcies.
So we've talked about in all three, 7, 13, 11 bankruptcies, but mainly about the proof of claim. So what happens after that proof of claim is filed? Is there anything that the lien holder has to do between then and whenever the debt gets settled? Yes. And again, this comes down to diligence. And I don't mean due diligence. I just mean plain diligence. Mm-hmm. And that is, when you're a tax lien investor who is stuck, and I do mean stuck, in the morass of a bankruptcy filing, because my clients want to be out of there. They don't like being in quicksand. They like to be free to do what they want. And so what they're doing is looking for a way out. And the legal way out is if you can get automatic stay relief. The automatic stay is that part of the bankruptcy code that stops you from enforcing your rights. It is automatic in that it starts the day of the bankruptcy filing. It's not as automatic if somebody is doing multiple filings, like a second filing within 1 year of a dismissal of a first filing, or a third filing. And I won't get into the differences, but suffice to say, the automatic stay is not quite as automatic if you're doing multiple filings. But in general, it stops you from doing anything. That's the point of the bankruptcy. You get all those people suing the person who has to file. They file a bankruptcy and everyone has to stop the lawsuit. So how do you get relief from that automatic stay? Well,
basically what has to happen is the debtor has to mess up. And mess up in the context of a tax lien holder almost always means not paying property taxes after the bankruptcy is filed. Because the bankruptcy code says you're obligated to stay in a bankruptcy to satisfy your tax obligations. And many debtors do not do that. Everything that was owed to the taxes before the bankruptcy was filed is part of their bankruptcy plan. But everything that's owed to taxes after the bankruptcy file is not in the bankruptcy plan. And so the failure to pay post-petition taxes is a violation of the bankruptcy code and can give a tax lien investor who is in that bankruptcy grounds to seek relief from the stay. Now, understand that it's not something you want to do on the first day. If somebody fails to pay that first quarter after they've gone into bankruptcy and you go and file that motion, the debtor will just turn around and you say, okay, I'll take care of it. And they take care of it. And you could have wasted your time. Most of my clients will wait 2 quarters, 3 quarters, 4 quarters, and see that taxes aren't being paid. And a lot of them will come to me and say, well, should I pay subsequent taxes? That's what I do. I'm a New Jersey tax lien investor. Not here. Never pay subsequent taxes in a bankruptcy because, first of all, think about the practical. You filed a proof of claim. Your claim has now changed because you're paying.
Right.
And if the debtor has a plan confirmed, you're not going to get the rest of that money paid because the plan's already been confirmed. On the other hand, that non-payment of taxes is sort of a weapon, or it keeps the debtor honest. You go in, and this is what happens 98 times out of 100. My client comes to me and says, I've been monitoring the taxes, and I see that the debtor's not paying and hasn't paid for 3 or 4 quarters. And I want to file a stay relief motion. I get the redemption statement from the collector that says, look at all these open taxes. I file my motion, my standard brief, my certification that attaches a certificate, says I filed a claim, he's not paying. And you know what, Your Honor? In addition to a violation of the bankruptcy code, you know what that's doing? It's creating a lien that's ahead of mine. Because in New Jersey, newer taxes are ahead of older taxes.
Okay.
And we can't have that. And the judge will say, you're right, you can't have that. You don't have to put up with that. So what does the debtor usually do? The first time around, it says, my bad. Says to the court, okay, I'm going to pay this. I'm either going to pay it right away, or if they don't have the money, I'm going to incorporate it in my plan, or I'm going to pay it over X number of months. The judge says, fine, because the judges want the debtor to succeed. But they say, okay, you're going to get a consent order, tax lien holder, that says this is what the debtor has agreed to do. And if he doesn't, and it goes on for 30 days, you can just send a certification into the court. You don't have to file another motion. And you'll get stay relief if they screw up again. Now, do the judges find a way around that? Yeah, they tend to. But it does give you a hammer, and sometimes it works. And by the way, they will also award, in some cases, some portion of your counsel fees that you spent on filing that motion. That will be included in the debtor's plan. So I always say it's a no-lose proposition for my client. You know, if you find out, not after 1 quarter, it's a waste of your time, but after a couple of quarters of non-payment of taxes, go to your attorney and say, file for stay relief.
And then it's, I guess, depending on the judge, multiple strike you're out situation, but in most cases 2 strikes.
Yeah, that pretty much does it. I've seen worse than that, but generally speaking, yeah, that's what you want to do. And I don't have to motivate my clients to do that because they hate being in the bankruptcy. They tell me, I get calls on the second day. How do we get out of this? Wait. We're not getting out on the second day. I can tell you that.
Patience, right?
Because the court system is set up for the debtors to succeed. If you come in there, guns a-blazing, saying, I want this guy to fail, you're going to be on the wrong side of that judge. Yeah.
So other than, I guess, filing for an automatic stay, or for relief in the automatic stay, Is there anything else that a tax lien holder can do or should do throughout the process of that bankruptcy?
Not really, because what's going to happen now, understand, I'm talking primarily about a Chapter 13. In a Chapter 11, yeah, there are other things you can do. There are other remedies. There's sort of the nuclear option, which is almost never taken, but I've seen a couple of times. A creditor can file a plan for the debtor in a Chapter 11 if the debtor hasn't filed within what's called the exclusivity period. And I've seen creditor plans where the creditor plan just said, sell all these assets and pay me. We don't care about this reorganization stuff. They're not doing it. And occasionally that'll get approved. But you have to be into it for a lot of money before you take on that kind of undertaking. The thing you have to remember is when you represent a creditor in a Chapter 11 or a Chapter 13, it's very difficult to get your clients' fees and costs reimbursed. So they have to be careful. They have to measure what they want to do in terms of their aggressiveness against the fact that there's a maximum amount they can recover. Everybody who does this knows that. And the more you take away from that to enforce your rights, the less your recovery is going to be. So everything has to be viewed with an eye toward what makes economic sense. How aggressive do I want to be in this case? You want to monitor it. In a Chapter 13, it's the trustee's job to make sure that the debtor's making the trustee payments, not your job. But you can see if the debtor's not making the trustee payments. You can say, trustee, he's not making payments. But frankly, the trustees have so many cases and they have such specific guidelines, they won't try to get a case dismissed for months after a debtor stops making trustee payments. So there's not much you can do about that. The answer is no. In most bankruptcies, all you can really do is watch, and your primary weapon is the failure to pay post-petition taxes. That's
So be patient, watch for payment of taxes. If there's no payments for a couple quarters, ask your attorney to file a stay. Otherwise, you just wait for it to play itself out.
And presumably, you're getting paid. You're getting a check every quarter from the trustee with interest. And even though it's not what you wanted, you are getting paid. I mean, Chapter 13 trustees disperse every quarter.
Okay, got it. Okay, so, all right. And that's really I'll say the second bucket of bankruptcy filings, which is the after the sale, but before the final judgment. So you'd mentioned that third bucket, which sounds like relatively new, which is the
relatively, I would say, in the last 5 years.
Okay, so in the last 5 years, but it seems to be becoming more common. But it's the filing of bankruptcies after the final judgment, technically after they've lost that asset, and they're basically claiming that asset back. So what's different from the other two buckets in that circumstance?
Well, this is my clients consider this to be just the worst case scenario, because what happens when they get the REO is, that's what they wanted. They can taste it. And for somebody to come back and say, you made too much money on this, we're entitled to this back. I say, no, that can't be right. And there are a certain number of bankruptcies, and I think there are going to be more bankruptcies that are filed with this specific intent in mind, meaning to recover. There are two bankruptcy code sections that give the debtor or the trustee the power to either get real estate back or to recover from the new owner, your client, the value of the equity. It doesn't have to be a return of the real estate. In some instances, it won't be a return of the real estate. It'll be a return of the equity. And those are called either voidable preference or fraudulent transfer. I want to start by saying, just to clarify, fraudulent transfer doesn't mean fraud. I mean, we all have a sense of fraud. Someone lied to me, somebody tried to get. Fraudulent transfer is a bankruptcy term that has nothing to do with actual fraud. It's just what they call it. There are two code sections. In the case of a voidable preference, it's a transfer that took place within 90 days of the bankruptcy filing, essentially that enabled the creditor to get more than it would get in a liquidation. And if you think about it, that's what you're trying to do. You're trying to get more than you would get in a liquidation. And in a fraudulent transfer, that look back period, if you want to call that, is 2 years. So for 2 years after the date of the transfer, if you recover more than you were entitled to when you acquired the property, either the property itself or the value of the equity in the property can be brought back. Now, why is it brought back? It's brought back not for the debtor. It's brought back to pay creditors. The justification for this, and it makes sense in the context of the way the bankruptcy system works, is to say one creditor shouldn't get all the assets of the debtor when there are other creditors out there who are not going to get paid. And when I'm owed $25,000 on my lien and I get a $100,000 property, $75,000 that would have gone to other creditors all went to me. And that's the justification for that, what we would call a clawback, meaning either the property comes back or the value of the equity comes back. Now, I could do an entire session on just this, and so I can't really get into all the nuances of it. Suffice to say that when it happens to you, if you go to an experienced attorney, and it doesn't have, somebody who knows what they're doing in this area, and it happens in New Jersey, and like I said, it happens in Illinois also, because it has to do with the fact that we are a bid down state. If we had an auction of the property like a sheriff sale establishes the value of the property. Even if it doesn't, it's deemed to establish the value of the property. Even if the bids are way less than the property value, it's still deemed to have decided that's what the property was worth. So there can't be a fraudulent transfer or avoidable preference. In New Jersey, where we bid down the rate, there is no bid up of the amount on the certificate. So that doesn't establish the value of the property. So what ends up happening is, and that's, I understand is also true in the Seventh Circuit, where they have the bid down, that you get the property, the debtor says, this property was worth a lot more than you're owed. I'm going to sue you to get it back. As soon as that happens, someone who has experience in this area will look at it and say, you've got defenses, you don't have defenses. They will be able to ascertain pretty early on. The only time where that might not take place is if there's a real dispute over how much the property is worth. Sometimes the debtor will say it's worth a heck of a lot more than you think it's worth, and so that's something that could be the subject of some dispute, and it could even involve getting dueling appraisals to see what the actual value of the property is. But generally speaking, everybody knows when the transfer took place, everybody knows how much was due on the tax sale certificate. That's not really an issue. So the only question becomes, how much is the property worth? But there are other more subtle issues. And again, in the white paper that you were looking at before, I listed some of the defenses that I have raised to them. To raise to these claims. I'll give you a very simple example. I don't want to spend too long, but
maybe we need to have another session, huh?
But I wiped out in a tax foreclosure in a commercial property a very large mortgage that was behind my tax lien. Very large mortgage, and that mortgage was far more than the property was worth, even under the debtor's assessment. So the debtor didn't claim that it had equity in the property. But since I took title of the property and had wiped out that mortgage, there was equity in it for me, or for my client. When the debtor sued my client to get the property back, I said to the court, you understand, this recovery has to be for the benefit of unsecured creditors. Meaning, if the debtor got that property back, the mortgage would reattach. It doesn't go away.
Right.
And so there was no equity for unsecured creditors. So the debtor couldn't recover the property. Because remember, we wipe out everything that's behind us by our foreclosure. Right. And if they undo our foreclosure, what we wiped out comes back.
And then there's no equity.
And if there's no equity, then there can't be any recovery. Now I was successful in that. There are other issues. I've seen attorneys win on the basis of the fact that it turns out that the transfer of the property, depending upon whether it's a fraudulent transfer or a voidable preference, either the debtor has to be rendered insolvent by the transfer or was insolvent at the time of the transfer. And sometimes the debtor owns other property. And you say, wait, you weren't insolvent. You have this other real estate. They said, well, I'm in bankruptcy. Yeah, but you don't have to be insolvent to be in bankruptcy. There's no test. You can file bankruptcy. People will file just to get the property back. And they say, yeah, but you're not insolvent. Now, I've seen people win. Now, there's a new case that just came down that might make a difference. In the last week, one of my brethren got a judge to write an opinion, not just a decision, write a reported decision that says the date of the transfer in New Jersey is the date of the filing of the lis pendens, not the date of the final judgment. I was shocked. But what this does is it makes the starting date for counting either the 90 days or the 2 years go back. Maybe 6 months, maybe 9 months, maybe a year. Because you filed the lis pendens at the beginning of the case.
Yeah.
Not at the end of the case.
Shortens the time period. You got to wait that 2 years, right?
Yeah, but that judge said, well, that was when the actual transfer took place. I said, woo. I said, I don't know where she came up with that, but I'm not arguing with it.
Right.
I'm perfectly happy with that decision. So that just came out. And like I said, I think I saw the decision come out in the last week, and that's going to be a new grounds for defending these actions. But generally speaking, most of the ones that I've handled have settled. Very few of them go to the point where the property is returned. And you want to make that decision early on. So I won't say any more about that. Let's just say it's the bane of the existence of a lot of my tax lien investors, the fact that this is happening. Mm-hmm. And when I say what you really have to do, and I say this all the time, is you have to modify your expectations, or put another way, and this probably from all over the country. The bigger the home run, the more likely someone is going to challenge it.
Yeah.
The more you think you killed it, the more likely it is somebody's willing to spend some money to undo it.
Oh yeah, bigger the treasure, the more people searching for it, right?
That's exactly right. And I try to tell my clients that, but I understand, where they're coming from. They say, hey, we got this great property. Yeah, well, that may be good. You got a bankruptcy judge who's not going to be thrilled about that. You even have some state court judges who are not going to be thrilled about that, even though we're not talking about the state court actions. They say, you did too well. We don't like that. So anyway, that's the story on fraudulent transfers and voidable preferences.
And you mentioned it's the biggest bane on investors right now in New Jersey. I guess for two reasons. One is that potential of having to give up the property or some of that cash, essentially, that you gained on the resale. But there's the other side of it. What are title companies doing from a title insurability standpoint? Does it put a big old kink in being able to sell the properties with title insurance for that?
You would think that, except for one thing. First of all, I haven't seen it, even though I get involved in a lot of REO transactions, and even though title companies are very, very, very careful about never having a claim. Mm-hmm. So I expected that would happen. And in fact, the first judge who wrote a decision on this, which was Judge Kaplan in Trenton, who wrote the first reported decision on this type of cause of action, in a seminar said, it was not my intention to screw up title. In fact, because people asked him, he said, in fact, I expect that most of the awards will be monetary awards, not a return of the property. In other words, it won't. But the other thing is, at least in my practice, my clients who acquire title by foreclosure are not themselves getting title insurance. The title insurance is kicking in on the first transfer, meaning they take title. My clients, at least the institutional clients, are not in the real estate business. They are in the tax lien business. And so they sell their REO usually as quickly as a title insurance company will insure it, which in New Jersey is between 90 days and a year, depending upon what's going on. Once that property is transferred to a third party, meaning not my client who took title, but to a third party in an arm's length transaction, And there wasn't any indication that anyone was trying to upset it, meaning the debtor hadn't filed that action yet. For the most part, the law is you're not going to get that property back from the third party. You might recover from my client some of that money that he got for selling the property, but that buyer is considered a holder in due course, meaning it didn't have any notice that anybody was making a claim to this property. And the courts enforce that. The courts, and there's even statutes that say, once it goes to a third party, unless you knew, meaning if that debtor hadn't filed that fraudulent transfer action yet, when you did that closing, they're not going to get the property back from the buyer. And I think the title insurance companies have concluded that that's the case.
Okay.
So I haven't actually seen it. I really thought it would be worse because frankly, the whole time I've been doing tax liens, as I came to us with a real estate background, most of my battles have been with title companies. and I was sure the title company was just going to say, well, here's another reason why we can't insure tax lien foreclosure properties. But they haven't actually. It hasn't been a problem.
Well, that could change.
And I recently settled one of these cases for what my client would say was a very good settlement in terms of, because I came up with some interesting defenses. But he had already conveyed the property to the third party, and and the third party came to me and said, well, should we be in this case? And I said, well, they haven't joined you in the case. You're not being sued. And so I said to the debtor's attorney after they found out we had sold it, well, he said, we're going to join the third party. I said, look at the law. I said, is there any chance you're going to get it from them? And he recognized that there was no chance. So I was able to resolve the matter without getting the buyer of the property from my client in the case or getting his title company in the case. And title companies always like it when they're not in the case.
Yes, that's always preferred on their end.
Yes, it is. I know, because sometimes I represent title companies and I know what they don't like. So anyway, so that's the answer is, title insurance is a big deal to us. You know all about the real estate around the country. Having title insured properties is a big deal in the tax industry. And so I was very concerned about it. And I have to say, thus far, my concerns have not come to fruition. There hasn't been a problem with it.
That's good.
We'll see.
Yes.
Maybe this judge who decided to start counting the time from when the Liz Pendens has filed is even helping that situation by backdating the date of the transfer to. So we'll see how that works out.
Excellent. Well, I guess, Bob, you mentioned that recent opinion that came out. I guess, is there any other anticipated changes, anything new coming down the pipeline that you're aware of?
Well, not so much in the bankruptcy. We're all seeing what's going on around the country with what is that, Pacific Legal? I'm not sure what the group that's trying to change the state laws, and that's not really in the bankruptcy context. The only reason why I bring it up is because if the changes in the state laws they're trying to effect are very much like the fraudulent transfer and voidable preference laws, saying that the debtor, the property owner, should own the equity above what's owed on the tax lien. But other than that, there are all kinds of modifications in the bankruptcy. Like there have been minor changes that have been made to the statutes to accommodate the pandemic, like the ability now to extend a plan in a Chapter 13 from 5 years to 7 years. That's going to be a short-term change. Let's hope it's a short-term pandemic. But that's already in place, and I've already seen some plans. The plan has to have already been confirmed, meaning you can't file a plan today that's 7 years, but if it was already a confirmed plan and you can prove that you need to extend it because of pandemic-related hardship, you can go out from 60 months to 84 months.
Okay.
Which, by the way, screws up my amortization schedule, as you can imagine, since I
all those 5-year plans. Yeah.
I went to a lot of trouble to explain to you how I'm so good at telling you how much you owe over 5 years, and the next thing I know, now it's 7 years. Well, I've been filing amended claims. So far, nobody's objected to it. We'll see.
Got it.
because even though you have a hard and fast deadline for when you have to file your first proof of claim, once you filed the proof of claim, then you can amend the claim if something changes. You don't have that same 70-day deadline.
Got it.
So that's why I say file that first proof of claim inside of 70 days. If you have to fix it later, you can at least say I had one on the docket. Now I just have to fix it.
Does that include if you filed it with the premium and you want to take it off? Is that an option?
I don't even want to go there.
All right, we'll leave that for another day then.
Oh well, and if only because if anybody read the cases on it, you would find out that in the big case, they did amend it. The judge said that shouldn't be there. They said, okay, we're amending our claim. They amended the claim. It didn't matter. The state court still said you tried to collect more than you were owed, even though you stopped trying. And in fact, you even said to the court, no, we're not trying anymore, really. No,
still wasn't good enough. Interesting.
Wasn't good enough.
Interesting. Well, Bob, I guess my last question for you, I like to ask everybody, I guess, if you had one piece of advice for investors looking at New Jersey, it doesn't have to be just for bankruptcies, just tax lien investing in general, what would be your biggest piece of advice or the biggest pitfall that you see investors fall into? That
same thing you would tell ananybody, and I tell people this all the time. Know your property. Mm-hmm. Because as I say because people call me up all the time and they want sort of they want to pay me for their course on tax lien investing in New Jersey, and I say, first I ask them if they've ever seen a title report, and if they haven't, then I say, I'm sorry, I can't talk to you. But the second thing I say is that there are only three ways it can go. You get redeemed, you own the property, you walk away. You don't want to have to walk away. So therefore, if you don't want to own it, there's a good chance nobody else does either. And assume that when you invest in the lien. That's, and it's the same thing you would tell them. You said, know your property,
Yep.
Don't invest if it's got Mercury in the name of the company that used to own it. Don't invest if it's landlocked. Don't invest. I've had clients who bought retention basins. Don't invest if it's a retention basin. So these are all the things that you have to be careful about. Anyway, for some reason, my computer has decided my battery is running low. I guess now it's not anymore. Anyway, that's it. It's everything about this, from the bankruptcy practice side, from the investment side, is paying attention. It's not something you do for fun. It's something you do to work at. Mm-hmm. You have to pay attention.
This isn't easy.
I was at a law firm many years ago, shortly after I got into the tax lien business, with about 40 attorneys, 15 or 18 partners, and they were living high on the hog, and they said, we know you know how to do this. How about if you set up a tax lien company for us to start investing some of our pension money in? And I said, okay, do you want me to continue to practice law? I said, because that's a job. I said, this is not something you dabble in like the infomercials on late night TV. I said, this is something that you have to pay a lot of attention to. And I said, I'm either going to practice law or I'm going to run your tax lien company. And they said, why don't you keep practicing law? I'm glad they went that way, because, I would, even as much as I know from my side, there would be so much more I'd have to learn in order to be on the. Remember, I don't see that tax sale certificate when that guy's in there bidding at the sale. I'm not.
You see later in the cycle.
All that work has already been done.
Yeah.
Anyway, so that's what I would say. Like you would say, pay attention.
Yep. Due diligence. Know what you're buying. Worst thing you do is just. And I think it's the worst thing that somebody's ever said or posted on the internet is that it's guaranteed, which is not true in any way, shape, or form. It's the worst thing you can assume.
I'll end with what I learned it from my very first job, which was at Capital Asset. And Capital Asset was one of the first major, institutional investors, and they would go in and buy every lien in a municipality, good or bad, every single one. And so that worked out real well at the beginning while the good liens were redeeming. Mm-hmm. And then they got left with all the bad stuff at the end because they owned everything. And you don't want to own everything. You want to own what you want to own, what you know, and the places that you know, and the values of the property that you know. So if you're
One
not
bad one will wipe out a lot of good ones, unfortunately.
Yep, that's right.
Yep. Well, Bob, I sincerely appreciate your time. I learned a lot. Even after reading your white paper, learned an immense amount more, just better understanding of how the bankruptcy process works in New Jersey. So thank you again very much. It sounds like there's several other topics we might get you back for in the future that wasn't worth touching on here just because it's a whole other episode. So anyway, I appreciate it.
Well, thanks for the opportunity. I appreciate it.
All right. Thanks again. Take care.
Bye-bye.